now we'll move on with our last speaker about to the issue of due process, right to due process, which, as we see, have an impact on all the different categories. So, Rod, you have the floor.
Thank you for the introduction, Glenn, and I'd like to thank the other panelists for their presentations. It was of great interest. I'm glad to take part. I'm going to be very, very brief, not least because I was a very late addition to this panel, but also because I think that your questions will be quite illuminating. First, I should say that I'm here to tell you that the Islamic Republic of Iran's approach to the UPR, as with its approach to all other UN human rights mechanisms, will not be a good faith approach. There are a number of reasons that we can be certain of that, but I'll get to them, especially in the assessment of violations of due process rights in Iran. First, I should give a quick introduction to what my organization does and why I'm here. IHRDC, the Iran Human Rights Documentation Center, primarily focuses on the collection of evidence regarding human rights violations. That evidence often takes the form of witness testimony from victims of human rights violations or the attorneys or relatives of such victims. As a result of the large amount of testimony that we gather on a regular basis, we're able to draw some conclusions regarding detention policy in Iran. And what a lot of this testimony tells us is that there's an increasing severity of pretrial detention, and that there are numerous violations of due process as required by international obligations to which the IRI ascribes, and also as required by domestic law. Pretrial detention is often the source of a lot of these due process violations. Pretrial detention in more serious cases, national security cases, some more serious criminal cases, can go on for weeks or months. There are numerous reports, countless reports nearly, of physical and psychological torture being applied to extract confessions. Although the IRI, for instance, accepted a recommendation to ensure access to attorneys in all stages of legal proceedings, domestic law and practice both do not follow this recommendation. Access to counsel is severely limited, especially in national security cases, and oftentimes the counsel themselves, when they are allowed to meet with their attorneys or with their clients, are only given a few minutes at a time, often just before trial proceedings begin. There are also numerous accounts of legal counsel being denied access to case files, and of course there are also ongoing attacks on individual lawyers, as mentioned previously, and on the legal profession more generally, both in practice and in a draft bill, which may be promulgated quite soon. One example of the lack of good faith that I was alluding to earlier was a statement by President Rouhani at the UNGA last month. He stated that there are no journalists imprisoned in Iran. And by their own definition, yes, these aren't journalists. The UNSR report indicates 35 imprisoned journalists. And these are people who are engaged in the collecting of reports and publishing reports. By any objective definition, these are journalists. But because they're charged with some of the lesser national security crimes, including distributing propaganda against the state, they're not classified as such by the Islamic Republic itself. So that's the kind of approach that you can expect. In addition, I'd like to raise the issue of evidentiary standards, given that Sharia in letter and also the Islamic Republic in practice place primary emphasis on confessions. Much of this pretrial detention is directed towards the extraction of confessions. And as a result, the solitary confinement, the psychological pressure, threats against family, physical torture, often in the form of blunt force trauma, hanging from ceilings, pressure points, and whippings, floggings, are incurred specifically with the goal of extracting those confessions. Numerous reports indicate that defendants in some of these national security cases especially aren't even given clear understanding of what it is that they're confessing to. But then if you read, especially from the death penalty cases, but in general, if you read court opinions, the evidence relied upon to secure convictions is primarily confessions, and of secondary importance is reports from officers of the agency that arrested the person in the first place. That is, the people who are extracting those forced confessions. So typically, the more serious the charge, the more serious the penalty, the lower the evidentiary standards. It goes without saying that although the Islamic Republic did not approach the first cycle UPR with good faith either, they did accept some suggestions in this regard, all of which they've ignored completely. One example is a recommendation from Chile regarding impunity for torturers. There are a number of interrogators who a good amount of witness testimony indicates are engaging in torture, and there have been no cases brought against them. In fact, testimony indicates that torture is still a matter of policy. As such, recommendations regarding the ratification of CAT also not followed. The recommendation regarding the guarantee of the presence of attorneys at all stages, as I previously mentioned, of legal proceedings, also not followed. Also of note with regard to due process is the IRI's complete disregard for the principle of legality. In HRDC's UPR pre-session submission, and in our UPR submission as well, we highlighted one particular problematic article of the Islamic Penal Code. There was a recommendation at the last cycle that apostasy, witchcraft, and heresy be removed as possible crimes. Article 220 of the Islamic Penal Code gives judges the right to issue sentences in hudud cases wherein crimes are not mentioned in the code itself. So when there's no statute referring back to an article in the Constitution, Article 167 of the Constitution, judges can actually rely on existing Islamic jurisprudence to issue sentences, including the sentence of death, for crimes including apostasy and witchcraft. Neither exists in the Islamic Penal Code as is, both can still be brought as charges. Heresy is actually still included in the Islamic Penal Code as well. So this is another example of a recommendation that was simply not followed. It's worth noting at this point that in national security and also in some criminal cases, especially more serious criminal cases, the Islamic Republic doesn't even follow its own laws and statutes. Some of those have been mentioned regarding furlough, medical leave, and some executions. Regulations on prison conditions and on executions are regularly not followed, as much of the testimony that IHRDC has gathered indicates. When cases fall within the IRI's very liberal definition of threats to national security, domestic laws are treated as optional. So you can imagine what recommendations from the international community, what weight they carry. So it's worth raising a few other issues that IHRDC pointed to in its UPR submission at this point that touch on routine due process violations that are currently going. One regards national security crimes as defined. They're very vaguely defined, especially some of the more serious ones. Muharebe, waging war against God, is defined as taking up arms against the state to stir disorder. But in fact, many Muharebe convictions are plagued by the poor evidentiary standards that I was pointing to before, and as a result, there can be no certainty as to whether or not even that very vague definition was satisfied. In addition, the issue of mahdur dam, or a legal category indicating that some are deserving of death, is also quite worrying. It gives individuals who have murdered others, for instance, a possible defense by pointing to possible apostasy or other possible criminal acts by their victims as indications that those people were deserving of death in the first place. Conviction is not needed for this defense to be used. The courts need not to have actually pronounced anything regarding a given victim's status as an apostate. It can simply be used as a defense as such. In a manner of speaking, it's giving private citizens the right to mete out punishment. It's parsing out sovereignty to private citizens. And when that punishment can also include death sentences, and the worst crime that a murderer can be accused of in such cases is simply stirring up public disorder, which carries at most a 10-year prison sentence. It's quite obvious, as the government's response to the acid attacks just in the last few days has indicated, that due process, that legality, that the security that correct prosecution and observance of laws as written and recorded would cultivate simply does not exist in Iran, and it's not a priority for the Islamic Republic. I'll stop talking now, and I'll let you ask questions if there are any. Thank you.
Okay, thank you very much, Ron, for all these very important points. So as you announced, I'm now happy to open the floor for questions and comments. If there is any question from the floor, I'm happy to take it. I give you 1 minute.
I've got a question.
Yes, please.
Jackie Henderson with the U.S. State Department. Do any of you cover treatment of journalists, freedom of expression? Is there anything you can say about that?
Yes, please.
Sure, yeah. As I mentioned earlier, I'm not sure if you might have been here. The typical charge is distributing propaganda against the state. There might be a charge of contact with foreign media. These are national security charges. They're tried in revolutionary courts. As a result of that, and I could have mentioned this earlier, revolutionary courts tend to have lower evidentiary standards than the public criminal courts, and it's not actually necessary to prove intent. It's simply necessary to have, you know, either extracted confession, to have reports by you know, elements of the security services who would like to see the journalist in question imprisoned, either, you know, individually or simply to deter other journalists from reporting. That's the level of evidence that's required. I mentioned before there in the UNSR report, counting of 35 journalists who are currently in prison. Exact numbers are difficult to come by because people are released and others are arrested and may not be reported in a timely fashion. So it's unclear if that number is precise today, but the point is that there are journalists imprisoned. The expression is criminalized, and it's framed as a threat to national security in order to do so. That's common practice with a number of forms of dissent, with a number of forms of simply demanding accountability from the government. We have a number of witness statements on our website from journalists who were imprisoned, especially after 2009 post-election unrest, who indicate that they were subjected to especially violent treatment. I can't say whether that's ongoing at this moment regarding the treatment of journalists, but indication has been that the restrictions placed on journalists and free expression generally, especially over the last 10 years, have been quite high. If you have any specific questions, I can try to address them.
Yeah, I'm thinking about now, well, on the internet, bloggers, social media sites. Does that even?
So that's even a separate category. There are plenty of people who are harassed or detained for that kind of activity as well. There are a number of bloggers who are currently imprisoned in Iran. You can refer to our website for the current accounting. I don't have the number in my head, but there's a specific security apparatus that deals with cyber crimes as they're defined by the Islamic Republic. So social media is often monitored. It's worth mentioning that even for people who you wouldn't categorize as social media activists or bloggers, one practice that's been reported in a number of cases is that when they're detained, they will be forced to give up passwords to all of these accounts, and all of their information will be thoroughly investigated. And membership in a group or having liked a page on Facebook is raised in interrogations and can be cause for increased harassment as well.
Okay, thank you. I think Shola, you had something to add on this issue?
Actually, as these acid attacks happened in Isfahan, there was kind of big demonstration of women with their families telling that they need really security in streets of Isfahan. And this was reported in one of Iranian news agencies, Islam news agency, if you have heard about it. The photograph of this demonstration and two other who allowed the print of this in the news agency, they were all arrested again. So this is the newest arrest that I have heard about. They were just arrested for reporting the demonstration. But of course they won't become a kind of such accusation, but something around about propaganda against regime or something.
Yeah. It's Good that you raised that. So yes, that's one of the photographers has been arrested. The editor-in-chief of ISNA in Isfahan and the social affairs editor of ISNA in Isfahan have all been arrested as of last night. And ISNA is essentially an official press apparatus. They weren't engaged in investigations for opposition purposes or anything. They were actually carrying out official duties. It's termed as a semi-official news agency, but it's essentially an official news agency. There's something very worrying about the rhetoric that's been used against them, and it's being utilized against the protests, which are simply demanding accountability. Now the acid attacks are being ascribed to foreign powers, and those who are demanding accountability are also being seen as pawns of foreign powers. I doubt significantly. I think it's very unlikely that the government actually believes that. But that's the rhetoric that's being employed. It's also the kind of rhetoric that you see used against Baha'is, even in internal documents in Iran. They'll refer to their activities and then in parentheses espionage. It's a common practice, and it's used specifically to throw cases into national security courts and assure that if the security services so desire, convictions will be secured.